In the United States District Court, Southern District of New York, Jane Doe, proceeding under a pseudonym, plaintiff, versus Donald J. Trump and Jeffrey E. Epstein, defendants. Jury trial demanded. Complaint for rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and defamation. Plaintiff Jane Doe, proceeding under a pseudonym, brings this action against Donald J. Trump and Jeffrey E. Epstein, and alleges that, parties, 1. Plaintiff is an individual residing in, and a citizen of the state of California. 2. Upon information and belief, defendants Donald J. Trump and Jeffrey E. Epstein each reside in this district, and are citizens of the state of New York. Jurisdiction and venue. 3. Plaintiff is a citizen of the state of California, for purposes of diversity jurisdiction, under 28 U.S.C. 1332. 4. Defendants are citizens of the state of New York for purposes of diversity jurisdiction, under 28 U.S.C. 1332. 5. This court has original subject matter jurisdiction, with respect to this action, pursuant to 28 U.S.C. 1332, as there exists complete diversity of citizenship between plaintiff and defendants, and the amount in controversy exceeds $75,000. Exclusive of interest and costs. 6. Defendants are each subject to the jurisdiction of this court pursuant to U.S.C. 1332, with proper venue pursuant to 28 U.S.C. 1391, as both defendants are residents of, or are domiciled in this district, and the events giving rise to the claims occurred in this district. Rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, and false imprisonment. 7. Plaintiff was subject to acts of rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and threats of death and/or serious bodily injury by the defendants that took place at several parties during the summer months of 1994. The parties were held by defendant Epstein at a New York City residence that was being used by defendant Epstein at 9 East 71st Street in Manhattan. During this period, plaintiff was a minor of age 13 and was legally incapable under New York law of consenting to sexual intercourse and the other sexual contacts detailed herein. New York Penal L. 130.05, 3a, the rapes in the first, second, and third degrees, sexual misconduct. Criminal sexual acts in the first, second, and third degrees, sexual abuse in the first, second, and third degrees, and forcible touching, and, on information and belief, predatory sexual assault, detailed herein are unlawful under New York law. Example: New York Penal L. 130.20, 130.52, and 130.55, 130.65, and, on information and belief, 130.95, and constitute the torts of, inter alia, assault, battery, false imprisonment, and intentional or reckless infliction of emotional distress, including threats of force and serious bodily harm, under New York law. In addition, 18 U.S. Code 255 provides plaintiff with a civil remedy for personal injuries because plaintiff, while a minor, was a victim of violations of 18 U.S.C. 159, 1-4-1, 4-2b, and 4-3a, and she suffered personal injury as a result of such violations. Declaration of Plaintiff Jane Doe. Exhibit A. Hereto. Declaration of Tiffany Doe. Exhibit B. Hereto. Declaration of Joan Doe. Exhibit C. Hereto. Jane Doe, Tiffany Doe, and Joan Doe are each pseudonyms as each woman wishes anonymity. Tiffany Doe, a witness, was an employee of defendant Epstein. Exhibit B. Joan Doe, a witness, was a childhood classmate of plaintiff who, in the 1994-95 school year, was told by plaintiff that plaintiff was subject to sexual contact by the defendants at parties in New York City during the summer of 1994. Exhibit C. 8. Courts of discretion, to allow proceeding anonymously, where the need for privacy outweighs the public's interest in knowing their identity and any prejudice to the defendants. Sealed Plaintiff versus Sealed Defendant, 537F3D, 185, 189, to D. circa 2008. This litigation involves matters that are highly sensitive and of a personal nature, and identification of plaintiff would pose a risk of retaliatory, physical harm to her and to others. Exhibit A. All of the 10 factors that the Second Circuit articulated as relevant to this analysis favor anonymity, especially factors 1 to 4, 7, and 10. Example, factors 1 and 2. Whether the litigation involves matters that are highly sensitive and of a personal nature, and whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties, or are neutral with respect to anonymity. Protecting plaintiff's anonymity is also appropriate, as she is a rape victim. 9. Plaintiff was enticed by promises of money and a modeling career to attend a series of parties with other similarly situated minor females, held at a New York City residence that was being used by defendant Jeffrey Epstein. At least 4 of the parties were attended by defendant Trump. Exhibits A and B. On information and belief, by this time in 1994, defendant Trump had known defendant Epstein for 7 years. New York, 10/28/02. I've known Jeff for 15 years. Terrific guy. Trump booms from a speakerphone. He's a lot of fun to be with. It is even said that he likes beautiful women as much as I do. And many of them are on the younger side. No doubt about it. Jeffrey enjoys his social life, and knew that plaintiff was then just 13 years old. Exhibits A and B. 10. Defendant Trump initiated sexual contact with plaintiff at 4 different parties. On the 4th and final sexual encounter with defendant Trump tied plaintiff to a bed, exposed himself to plaintiff, and then proceeded to forcibly rape plaintiff. During the course of this savage sexual attack, plaintiff loudly pleaded with defendant Trump to stop, but with no effect. Defendant Trump responded to plaintiff's pleas by violently striking plaintiff in the face with his open hand and screaming that he would do whatever he wanted. Exhibits A and B. 11. Immediately following this rape, defendant Trump threatened plaintiff that, were she ever to reveal any of the details of the sexual and physical abuse of her by defendant Trump, plaintiff and her family would be physically harmed if not killed. Exhibits A and B. 12. Defendant Epstein had sexual contact with plaintiff at 2 of the parties. The second sexual encounter with defendant Epstein took place after plaintiff had been raped by defendant Trump. Defendant Epstein forced himself upon plaintiff and proceeded to rape her anally and vaginally, despite her loud pleas to stop. Defendant Epstein then attempted to strike plaintiff about the head with his closed fists, while he angrily screamed at plaintiff that he, defendant Epstein, rather than defendant Trump, should have been the one who took plaintiff's virginity. Before plaintiff finally managed to break away from defendant Epstein. Exhibits A and B. 13. The threats of violence against plaintiff and her family continued, this time from defendant Epstein, who again reiterated that plaintiff was not to reveal any of the details of his sexual and physical abuse of her, or else, specifically, plaintiff and her family would be seriously physically harmed, if not killed. Exhibits A and B. 14. While still under threats of physical harm, by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted, plaintiff, who has suffered from stress, emotional distress, mental pain and suffering, among other problems. Ever since the assaults, was subjected to daily painful reminders of the horrific acts of one of the perpetrators, Defendant Trump, via mass media coverage of him starting on or about June 16, 2015, that, over a short period of time, became continuous and unavoidable. Exhibit A, 15. As a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has suffered stress, emotional distress, and mental pain and suffering, as well as adverse physical consequences. 16. As a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has suffered physical pain and suffering. 17. As a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has been subjected to public scorn, hatred, and ridicule, and has suffered threats against her life and physical safety. 18. As a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has incurred special damages, including medical and legal expenses. 19. The sexual assaults and rapes perpetrated by defendants upon plaintiff were intentional acts. 20. The conduct of defendants demonstrates willful, reckless and intentional conduct that raises a conscious indifference to consequences. 21. At the appropriate time in this litigation, plaintiff shall amend her complaint to assert a claim for punitive damages against defendants in order to punish defendants for their actions and to deter defendants from repeating their conduct. Tolling of statute of limitations. 22. Any statute of limitations applicable to rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, false imprisonment of a minor, if any, is told owing to the continuous and active duress imposed upon plaintiff by defendants that effectively robbed plaintiff of her free will to commence legal action until the present time. Cullen vs. Marjota, 811F-D, 6987-2, 2nd Circa 1987. Ross vs. United States, 574, Federal Supplement, 536542, Southern District of New York, 1983. More particularly, plaintiff was unrelentingly threatened by each defendant that, were she ever to reveal any of the details of the sexual and physical abuse caused to her by defendants, plaintiff and her family would be physically harmed, if not killed. The duress has not terminated, and the fear has not subsided. The duress is an element of or inherent in the underlying causes of action complained of herein. The duress and coercion exerted by defendants has been such as to have actually deprived plaintiff of her freedom of will to institute suit earlier in time, and it rose to such a level that a person of reasonable firmness in plaintiff's situation would have been unable to resist. Exhibits A and B, 23. Both defendants let plaintiff know that each was a very wealthy, powerful man and indicated that they had the power, ability and means to carry out their threats. Indeed, Defendant Trump stated that plaintiff shouldn't ever say anything if she didn't want to disappear like Maria, a 12-year-old female that was forced to be involved in the third incident with Defendant Trump, and that plaintiff had not seen since that third incident, and that he was capable of having her whole family killed. Exhibits A and B, 24. The duress had prevented plaintiff from starting litigation before this year. However, as soon as she surfaced, she received threats. More specifically, shortly after her first complaint was filed in California on April 26, 2016, she started receiving threatening phone calls. On her cell phone, Exhibit A, 25. Defendants are equitably stopped from arguing that any statute of limitations has not been told, as defendants wrongfully force plaintiff to refrain from timely commencing this action by threats, duress, and other misconduct. Exhibits A and B. Zimmerman vs. Poly Prep Country Day School, Federal Supplement, to D. 2012. 2012 WL 3683393. General Stencils, Inc. versus 𝗧𝗿𝗱𝗶𝗁𝗱, 18 New York, to D. 1-5-127, 1966. A wrongdoer should not be able to take refuge behind the shield of his own wrongdoing. 26. Moreover, this action has been brought before the facts giving rise to the estoppel have ceased to be operational, i.e., while still under threats of physical harm, by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted, and since plaintiff has decided to seek redress at this time, plaintiff seeks an order of protection in favor of plaintiff and all associated with her, so as to protect them from harm and harassment from defendants and their agents and associates. Exhibit A. Defamation 27. On information and belief, on or about April 28, 2016, Defendant Trump provided the following statement to American Media, Inc. and or Radar Online, LLC, for publication on at least their website radaronline.com. Dean Plaintiff's Complaint EDCV 16797 DMG KSX, filed in the United States District Court for the Central District of California. The allegations are not only categorically false, but disgusting at the highest level and clearly framed to solicit media attention or, perhaps, are simply politically motivated. There is absolutely no merit to these allegations, period. The statement provided for publication by Defendant Trump was published by said website and has been republished elsewhere in whole or in part numerous times, and similar statements of an attorney for Defendant Trump were also published, including on September 22, 2016, by Courthouse News Service. The statements provided for publication by Defendant Trump and his agent, and that were published by said websites, are false as they pertain to plaintiff. 28. The published statements are libelous on their face, and clearly expose plaintiff to hatred, contempt, ridicule and obloquy. 29. As a proximate result of the above described publications, plaintiff has suffered loss of her reputation, shame, mortification, and injury to her feelings, all to her damage in an amount to be established by proof at trial. 30. The above described publications were not privileged, because they were published by Defendant Trump and his agent with malice, hatred and ill will toward plaintiff and the desire to injure her. 31. As a direct and proximate result of Defendant Trump's defamation of plaintiff, plaintiff has been subjected to public scorn, hatred, and ridicule, and has suffered other injury. Prayer for relief. Wherefore, plaintiff prays for judgment against defendants, and for the following relief: A. That judgment be entered against defendants for special damages, compensatory damages, and punitive damages in an amount which shall be shown to be reasonable and just by the evidence, and in excess of $75,000, exclusive of interests and costs. B. That all costs of this action be assessed against defendants, including all reasonable attorney's fees, costs, and expenses of this action. C. That an order of protection in favor of plaintiff and all associated with her be issued, so as to protect them from harm and harassment from defendants and their agents and associates, and D. Such other and further reliefs as the court may deem just and proper. Jury demand. Plaintiff demands a trial by jury of all issues properly triable by jury in this action. Dated September 30, 2016. Trump rape accuser dismisses, New York case. Adam Klasfeld. November 4, 2016. Manhattan, Courthouse News. The woman accusing Donald Trump in a Jane Doe lawsuit of having raped her when she was 13 years old voluntarily dismissed her lawsuit Friday, for what appears to be third time. The dismissal comes with less than a week to go before voters cast their ballots in the presidential election, pitting Trump for the Republicans against Hillary Clinton for the Democrats. Doe filed this federal complaint in New York for the first time on June 20. She withdrew the suit on September 16, however, only to refile with another witness, an additional defamation count, and a new attorney who once represented Casey Anthony, the Florida woman famously acquitted of killing her daughter. Though set to appear in her first press conference Wednesday, attorney 𝗧𝗿𝗱𝗶𝗁𝗍 explained that they cancelled the event at the last minute because Doe had received threats. "She's living in fear," Bloom told reporters then, referring to Jane Doe. "She has decided that she's too afraid to show her face. She's been here all day ready to do it, but unfortunately, she's in terrible fear. So we're going to have to reschedule." Late Friday afternoon, Doe's old attorneys, New Jersey patent lawyer Thomas Meagher and the Florida-based Cheney Mason, a co-counsel on Anthony's high-profile defense team, filed a motion dismissing the New York lawsuit without explanation. Neither the attorneys nor the Trump campaign responded to email requests for comment. Bloom, Doe's new legal muscle, is the daughter of women's rights lawyer Gloria Allred, and her assistant did not immediately return an email inquiry. Vehemently denying the allegations, the Trump organization's Alan Garton previously told Courthouse News that the charges are completely frivolous and appear to be politically motivated. Doe remains anonymous, but did reveal that she previously sued Trump in California. The details correspond to a federal complaint filed pro se this past April in Los Angeles by a plaintiff named Katie Johnson. A magistrate judge reportedly tossed that case in May, 1 month before Doe's New York suit appeared. Doe's New York complaint accused a presidential nominee and disgraced financier Jeffrey Epstein, taking turns in a savage sexual attack against her at an Upper East Side mansion in 1994. The lavish parties that Epstein, a convicted pedophile, threw on his private jet and mansions have ensnared multiple notable figures. The sordid and unproven accusations have swept up Harvard attorney Alan Dershowitz and Britain's Prince Andrew, among others. According to a British newspaper, the latest case tied to Epstein may have a wrinkle involving Jerry Springer, the former king of tabloid talk and daytime television. The Guardian reported that a former Springer producer appeared to have coordinated Doe's lawsuit, and that a publicist tried to sell a video of Doe describing her allegations to media outlets for $1 million.